So this week I wanted to look at the Apple state aid case from July 2020. And it is, although it is not about transfer pricing, it is about European state aid, it is actually all about transfer pricing. But in the end, the case is also lost in something what is not transfer pricing. So it's a bit of an interesting twister. And let us get into it. I will briefly describe the structure, then give a little more background information, and then we'll dive into the court decision itself. Spoiler alert, the Commission lost and Apple did not have to pay back billions of euros of state aid. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. So let us look at the relevant corporate structure. Apple Operations Internationally is a fully owned subsidiary of Apple Inc. at the top, right? And Apple Operations International fully owns the subsidiary Apple Operations Europe at the bottom, which is AOE, which in turn fully owns the subsidiary Apple Sales International, ASI. ASI and AOE are both companies incorporated in Ireland but not tax resident in Ireland. And a significant number of the members of the boards of the directors of AOE and ASI were directors employed by Apple Inc. and based in Cupertino. So I think only one person was actually based in Ireland. And then Apple Inc. on the one hand and ASI and OE on the other hand were bound by a cost-sharing agreement or a cost contribution agreement. The shared costs concerned, among others, the R&D of technology incorporated Apple Group's products. The initial cost-sharing agreement was signed in 1980. The parties to the agreement were, and that's an old company, so they've changed names in the meantime. And then under that agreement, the parties agreed to share the costs and the risks associated with the R&D. And they also agreed that Apple Inc. remained the official legal owner of the cost-sharing intangibles, but these companies then got the economic ownership, would be the argument. In addition, Apple Inc. granted ASI and AOE royalty-free licenses, enabling those companies, among others, to manufacture and sell the products. Because it was a cost-sharing agreement, they were paying for the cost for contributing these, for generating these intangibles. And they could sell the products in the world except for North and South America. The parties to the agreement were required to bear the risks resulting from that agreement, the main risk being the obligation to pay for the development cost. Right, so that was a CSA, and then there was a marketing agreement or marketing service agreement that was concluded in 2008 with Apple Inc. and ASI, in connection with which Apple Inc. undertook to provide marketing services to ASI. ASI undertook to remunerate Apple Inc. for those services by paying a fee corresponding to a percentage of the reasonable costs incurred. Okay, and then ASI and AOE set up Irish branches. ASI's branch is responsible for, among others, carrying out procurement, sales and distribution activities associated with the sale of Apple branded products to related parties and third-party customers in the regions covering Europe, the Middle East, India, Africa and the Asia Pacific region. The key functions within that branch was to include the procurement of Apple branded finished products from third-party and related party manufacturers, and distribution activities, online sales, logistics operations, and operating an after-sales service. So that was ASI. And then AOE was responsible for the manufacture and assembly of a special range of computer products in Ireland, such as iMactops, MacBook laptops, and other computer accessories. The key function within that branch included the production, planning, and scheduling, process engineering, production and operations, quality assurance and quality control, and refurbishing operations. So this was the structure and these were the activities of the different entities involved. And now we get to what the case is about, right? Because then in 1991 and 2007, these two Irish companies got tax rulings from the Irish tax authorities about their tax base in Ireland. And in both cases, it was for the sales activities. There was a small turnover-based compensation, but for most of it, the compensation was a cost-plus based compensation. So it was a low-risk routine compensation that was agreed with Ireland for the activities which were allegedly performed in Ireland, and not for anything outside, because these were non-dom companies, therefore they only paid tax on their branch income. And these are the rulings that the Commission has attacked, saying basically that they were not at arm's length, that the profit allocation was not good, that it didn't include all the activities of the companies, etc., etc. And this is what brought us to the Court of Justice. But before we go to this, or the Court of First Instance, let us just very quickly look at the article dealing with state aid, and then we're going to get into the court's decision itself. But even before we do that, let me take a few minutes and just give you the bigger picture of what exactly is going on here and why the Commission attacked this structure. So let us just start with a bit of background as to what is actually going on, because you will understand the Commission's actions better if you have this in mind. So what do we have here? We have the Apple Irish companies, so-called non-dom companies, right? Which means they are incorporated under Irish law, but they're not domiciled in Ireland or resident in Ireland, and therefore they're only taxed for their branch activities. Now these companies themselves have been very popular in the past. They've been criticized in the late 90s for being used for illegal activities, drug trafficking, money laundering, etc., etc. And then they tightened the rules and actually got rid of them, but left open a possibility for US multinationals to use them for Irish Dutch sandwiches, among others. So we have the non-dom, and it has Irish branch activities. And now the issue is, as the case say, there's 0 employees in the company itself outside of Ireland. There's 0 cost, maybe a registration fee here or there, but that's basically it. There's a couple of thousand of employees in the Irish branch in Ireland, responsible probably, I don't know, because the case doesn't say, for 99% of the total OPEX of that company. And yet the branch makes a routine limited risk profit, and the Apple companies themselves get the residual, right? And make no mistake, the residual may be billions of euros. So the frustration of the Commission is there is nothing outside of Ireland. Why is this not taxed in Ireland? And we'll get to the case and how the Commission ultimately lost the case. But there is a second part of the picture to bear in mind, and that is you've got Apple Inc. in the US, where everything is happening, and you've got these Irish non-doms which hold the Irish branches. And there's, among others, but crucially, a cost contribution agreement between Apple Inc. and the Irish non-doms. And I say crucially because, you know, if the Irish non-doms were not taxed anywhere and they had passive income and they were low tax, etc., they would have fallen under the US Subpart F rules or the US CFC rules, but they don't because of this CCA. You see, in the deal with the CCA is that you pay half the research and brand building and all that, or whatever part of the world income you enjoy, you pay that much for whatever is happening in the US, and then you get this access to all these profits, right? And they don't fall under Subpart F because you've entered into the CCA and because you are supposedly, at least at that time, you were co-developing and co-R&Ding all this stuff. And so now what you see is that all the value-adding functions and decisions and control of risk is happening in the US. The Irish company just does the low-risk routine functions which happen in the branches in Ireland. It's got no other people that can do anything else. And yet it gets much more profits than the functions performed or risk controls, because effectively the CCA is not at arm's length. And this is part of what's been fixed under BEPS, and that's why they fixed Chapter 8 on cost contribution agreements and said, you cannot have these situations anymore where one of the participants only provides cash and nothing else. But this is the issue. What the Commission tried to do is it tried to drag into the Irish branch. So let's just create a pointer here. It tried to drag into here all the non-arm's length profits essentially that was made in this deal and which was then stateless up here. So let's say that Ireland, and I'm just quoting rough numbers, purely imaginary, let's say that in any one year it earned 1.5 billion euros in sales outside of the US and South America, and that was what went to Irish companies. The Irish branch activity maybe had a cost base of 200 million euros, and let's say they paid a profit tax on that on cost plus 20. That was it, right? So of that 1.5 billion euros, not necessarily all profit, but let's just say profit, 200 million cost plus 20 on that was what got taxed in Ireland. So a lot of money escaped taxation both in Ireland and in the US, and that was what the Commission was going after. So let's see what happened in this case. Okay, so let us now look at what the Treaty on the Functioning of the EU says. And here you can see it's the consolidated version from March 2010, which is around the time of the events of this case, right? And then we need to look at what state aid rules say, and they say, Section 2, aids granted by state. Any aid granted by a member state in any form whatsoever which distorts competition by favoring certain undertakings shall be incompatible with the internal market. And why is this? So imagine you have a shipping company in Denmark that is doing pretty well, but the shipping industry is tough, and it does its best to survive. And then you have a shipping company, for instance, in Germany. I'm just taking a random example here. And the German industry, the German Ministry of Transport or whatever, decides, you know what, we have a shipping company and this cannot go under. So it supports that shipping company, even though technically it should not survive because it simply does not do what needs to be done in order to survive in a global shipping market. What happens is the Danish shipping company is now competing against the German shipping company on unfair terms because the Danish company doesn't get any state aid. The German one does. So, you know, if the Danish company needs to cut prices just to be able to compete with the German one, then the German can cut prices further because it's getting state aid. That is not fair competition. In the end, what happens is the Danish company goes bankrupt. The German company survives, but the German company is basically a sick company that should not be in the market at all because it cannot compete with the rest of the world without German taxpayer money. So in order to stop this kind of thing, the state aid rules within the EU says you cannot support a company that cannot stand by itself. It should be able to compete without taxpayer assistance, right? Or all of them should be able to. And there's a whole list of things that are allowed to receive state aid, but the rules are you must ask and you must ask first. If the Commission approves the state aid, then you can provide it, but if they haven't approved it, then you cannot provide it. And if it turns out that you cannot provide it, and you have, then you actually have to get it back. And the reason why you have to get the money back is not a punishment, but what happens is you try to restore the situation as it was before the illegal aid was granted. So before the illegal aid was granted, there was no money given to the taxpayer. So you need to take the money back that you have given to the taxpayer plus interest. And this this look-back rule can apply up to 10 years. So what the Commission did was it said that by giving the tax rulings to Apple, Ireland actually provided illegal state aid to Apple, and it needed to stop that, and it needed to collect back the money that it should have collected in taxes, which it did not collect because of these favorable tax rulings. And the whole issue that is discussed here for state aid to be illegal is you must get special treatment, or there must be an element of selectivity. In other words, that you must be treated better than other companies in your country. That is state aid. If you get rid of corporate income tax and no one has to pay corporate income tax anymore, then there can be no state aid because you treat everyone the same. But if you give certain taxpayers an advantage over others, and they deal within the EU whereby they distort the competition within the EU, then you have to collect back that money, and things like national statute of limitations or national doctrines about legitimate expectations simply do not count, because the EU point of view is that especially these multinationals, have very expensive advisors. They should be aware of state aid rules. They should be aware of the fact that these companies need to make sure that the Commission approves the state aid, and therefore the fact that they cannot rely on the member states' opinion. They should be aware of the fact that they should rely on the Commission opinion and the Commission's opinion only. It's kind of a rule that says, you know, if you take part in Europe in the economic traffic, then you are supposed to know the rules, just like you would if you were in the US. So let us see what the court decision actually has been.